You know, your job is a huge part of your life. But let me ask you, do you really know your rights as a Canadian employee? From the day you start to the day you leave, understanding the rules of the game is absolutely critical. So today, we're going to break it all down. It's a tough question, right? And it's one most of us really hope we never have to think about. But what happens when the unexpected hits? A layoff, a sudden demotion, or even getting fired? Are you actually prepared? Knowing your rights isn't just some nice-to-have piece of trivia. It's essential for protecting yourself and your family. So here's our game plan. First, we're going to untangle Canada's kind of complex employment rulebook. Then, we'll dive right into what's happening in the layoff landscape today. After that, we'll unpack a really important concept called constructive dismissal. And we'll wrap it all up with the key takeaways that are going to empower you in your career.
First up, let's talk about the rulebook. The single most important thing to get your head around is that in Canada, there isn't just one. It's more like a patchwork quilt of laws, and the rules can change completely depending on where you work.
So get this. Instead of one big unified system, Canada has 14 different sets of employment laws. You've got federal laws that cover specific industries like banking or airlines, but then every single one of the 10 provinces and 3 territories has its own unique rule book. It literally means your rights as an employee can change just by moving across a provincial border.
And here's a perfect example of that patchwork in action. Minimum wage. I mean, look at this. In Nunavut, it's $19 an hour. In BC, it's pretty close to $18. But then you look over at Alberta, and it's $15. That's a $4 difference every single hour, all depending on which government's rules apply to your job.
And it doesn't stop with wages. Take a look at vacation time. If you work for 10 years in Saskatchewan, you are legally entitled to 4 weeks off. But with that same decade of loyalty in British Columbia or Quebec, you only get 3 weeks. These are the kinds of details that can make a huge difference in your actual life. Okay, so we've covered the day-to-day rules. But what happens when your job itself is on the line? That brings us to our next section, the layoff landscape. And wow, is this a timely topic. A recent survey found that a staggering 50%, half, of Canadian employers are expecting to lay people off. That's 1 out of every 2 businesses. So this isn't some far-off possibility. It's the reality for a lot of people right now, which makes knowing your rights more important than ever. So if a layoff does happen, you need to know which kind it is. First, you've got a temporary layoff. That means the company plans to bring you back, and you have what are called recall rights. Then there's a permanent layoff, which is exactly what it sounds like. The job's not coming back, and full severance rules kick in. And finally, there's a mass layoff. This is when 50 or more people are let go, and that triggers special rules with longer notice periods. It's also really important to know the difference between a layoff and a job shutdown. A shutdown is way more final. The whole company or your specific location is closing its doors for good. This means full severance is triggered right away. A layoff, on the other hand, might just be temporary, and you might have the right to get your job back. It's a subtle difference, but legally, it's a huge one.
All right, now for a concept that every single employee in Canada should have in their back pocket: constructive dismissal. It sounds a little jargony, I know, but it's all about what happens when you aren't actually fired, but you feel like you're being forced to quit.
Just imagine this for a second. You haven't gotten a pink slip. Nobody's officially told you you're fired, but maybe your boss has changed your job so much, or the workplace has just become so toxic that staying feels impossible. You feel like you have no choice but to leave. What are your rights in that situation? Well, this is exactly where constructive dismissal comes into play. The law basically says that an employer can't get around paying you severance by just making your life miserable until you quit. If they make a major, one-sided change to your job, or if they create an unbearable environment, the law can treat your resignation as if you were fired. And that means you could be entitled to a full severance package. So what are the red flags here? What should you be looking out for? Well, big things, like a huge cut to your pay or bonus, a sudden demotion, being forced to relocate somewhere you don't want to go, or having to deal with harassment or just a really hostile environment. Even having your main job duties taken away can count. These aren't just bad days at work, these could be the building blocks of a constructive dismissal claim. Okay, so we've covered a lot of ground, and all of this brings us to the most important part, turning this knowledge into action. Let's talk about the key takeaways you need to protect yourself, your rights, and your future. Now check out this quote. It's from Quebec's Civil Code, but the idea behind it is powerful and applies right across the country.
What it's really saying is that you cannot sign away your basic right to be treated fairly when you're let go. The law protects you, even if your employment contract tries to take those rights away.
So if you are ever let go, what do you do in that moment? I want you to remember these 3 immediate, non-negotiable steps. Number 1, carefully review whatever severance package they offer you. Number 2, and this is so important, do not sign anything right away. You are allowed time to think about it. And number 3, get some professional legal advice so you can understand what you are truly owed.
And here's exactly why that legal advice is a game changer. The minimum severance amounts written into the law, think of that as the absolute floor, not the ceiling. It's the starting point. Based on things like your age, your position, and your years of service, the common law could mean you're entitled to much, much more. You don't want to leave that money on the table.
So we'll leave you with this final thought. Your job is a contract, whether it's 100 pages long or is just sealed with a handshake. It sets out the rules for you and your employer. Understanding that contract and the laws that back it up is the single most powerful tool you have. So the real question is, are you sure you know what's in yours?